Good morning. Good morning. If there is anyone here that came for the PTOT workshop, they've been sending people to this room instead of Highland Lake. So if you're here for that workshop, just go across the hallway. We'd love to have you in here, but we won't be talking about PTs and OTs.
Yeah, we will.
Oh, yeah, we will after you leave. So the other thing is, if any of you have munchies or didn't eat breakfast, we have a bake sale going in. You probably saw it when you came in. So please help yourself going down there. You do have to pay for them, but I haven't been down there to see what all they have, but I've seen some things coming in the door that look pretty darn good. So at break time, you might want to mosey down there if you're hungry and grab something. Seemed like there was another announcement. Who is telling me the announcements? Now I've forgotten what somebody told me. Melanie, did I get everything you told me? Okay. Well, we're going to get started this morning. We only have 3 agenda items. That's a first for us, really. We've never had that few, but we've got some great information. We're going to start off with Denise. Then we're going to talk about needs assessment, or what's the right name? That's old school to call it needs assessment. No. I'm going on after the legal update. We're going to be talking about systemic data analysis. If you're old school like me, needs assessment. And then we're going to talk about T-test. We've got a lot of requests to talk about what do you do with teachers in special education classrooms for the T-test. So we've got someone going to come and present on that. So 3 big topics. And I think Denise has some new news for you when she presents, some new information from TEA. Yes, so I'm going to turn it over to Denise, and we're going to move forward with Denise, and then we'll move into our other agenda items. Thanks, Denise.
Can y'all hear me? You can now. All right. I have some old information and new information pertaining to TEA disputes. Think about your last ARD you attended, and you thought everyone ended in agreement. And then the next day you got a request for mediation. Or you didn't even go to an ARD meeting, and then you look on your fax machine or email and it's a request for mediation. And then I get a phone call from a director saying, I just got a request for mediation. We haven't even had an opportunity to go to ARD yet. What's with this? And last time I was here, I took a little random poll to see how many of you have been involved in mediations this year or have had a request for a mediation. And I saw an awful lot of hands go up responding to the fact that mediations are on the rise. Now, my slide presentation is mediation is a viable option to move beyond an impasse. And I think in terms of the disputes and the conflicts you have in special education, which are many and which are growing, this is one tool that's available to get you some relief, to get the parties to move forward in a way where they can work together. And also, it's a means to start over. And we're going to talk a little bit about that. So how many of you have been involved in mediation this year already? Quite a few. And so how many expect to have more mediations in the spring? I would think so. You have 3 next week. Sir, what's your drink of choice? Okay, so, all right, that's a lot of mediations, and it can drain you. But let's talk about what I like about mediation. First of all, the state was required to come up with something for dispute resolution, and that's and federal law allows this. You have parents and schools resolve disputes through a mediation process even before a parent files a due process hearing. So you're saying, wait a minute, I can have a mediation request and there's not an ARD and there's not a hearing? Yes, and that's a good thing coming from someone who litigates these issues. In accordance with federal law, TEA provides mediation as the method of resolution. And here's what I like. If you can resolve your concerns at the lowest level possible, and you've heard this, for those of you who've had some good mediators, you control the outcome. Not a random judge or a random SOA hearing officer who doesn't know much about the law or the parties. So it would be imperative for you to consider, when you get a request for mediation, to determine whether or not it could actually meet your needs and advance the relationship between the parent and the school district. Now, let's talk about, before I go on, and Shirley's keeping me on a tight schedule, so I'm going to be as brief as I possibly can. When you get that mediation request, you also don't have to say, yes, I'm willing to mediate. Now, the reason we have a lot of mediation requests, I essentially touched on last time. That is, you have a lot of advocates who can request mediations, right? There's a lot of advocates that are floating around at every district. Sometimes the same advocate is everywhere. It's a miracle. There are different school district every single day, but they're able to do that. The other reason is because we have just kind of an uptick of litigation to begin with. So you're seeing a lot of just requests for mediations come in. Now, when you get that, does that automatically mean you've done something wrong? Absolutely not. That is not a red flag. That does not suggest that you are in the wrong. And in fact, when you settle things, it doesn't mean you're in the wrong either. Sometimes you settle issues because it's more cost effective. The way I look at mediations, and I've known some clients where I've discussed this with them, is that you sometimes settle things, and particularly idea claims, as a cost of doing business. And you have to convey that to your superintendents or those up the food chain who need to understand the cost involved should you not mediate. When you get a request for mediation, I would go to look at the child's records, and you're going to examine FAPE. Really simply, briefly, was the student's program individualized? Was it based on assessment? Do you have an assessment that's timely? Was the child making progress? So I'm going to look at the 4 factors of FAPE. LRE, stakeholders. Did you have key stakeholders involved in the process? So I'm going to look at that and then decide, is it worth going forward to mediate this particular dispute? And you're sitting there going, but we've not done anything wrong. So that's when you get to the point of having to analyze. So you've done your FAPE. You said, we haven't done anything wrong. But you may have somebody who's really highly charged, type of a parent or advocate, who is essentially besieging the school district with PIA requests, open records requests. They're filing grievances, SBEC complaints, all of the above. And you just kind of want to stop the madness. And you want to get a fresh start and see if you can't roll it back a little bit, go to mediation, and then move forward in a hopefully peaceful manner. That's another reason you would do it, even though you hadn't done anything wrong. And it all comes down to what's your authority to offer money. Mediations, most of the time, at least when I'm involved in them, will require a certain amount of money. An advocate or an attorney expects to get some money for doing their job on the other side. The claim is, at least for an attorney, is the attorney's going to say, look, if I went to a special ed due process hearing and I represented my client through that process and I won on any issue, I would be entitled to attorney's fees. So I'm essentially denying myself that opportunity to litigate, and I'm going to just take some money here and move forward. So it's also called consideration, meaning you want a binding agreement. If you pay money, you get something for it. So what's the number one thing, and I'm not really getting into the nuts and bolts of what a settlement agreement looks like, but the number one thing I suggest that you try to achieve in the mediation process is to get what's called a release of all claims. And what that means is the date you enter that settlement agreement, the effective date of that settlement agreement and back is water under the bridge. It can't be raised again as a claim. You start over. You can't be sued over claims that are released. You may say, well, has that ever happened where they had released the claims and then the parent comes back and refiles? Yes, it's happened. And then we sent the parent a demand letter for $35,000 for violating a settlement agreement. It's binding. And the parent moved, didn't pay us, but the parent did move. So it's a binding agreement. And that release is gold in your shoes, particularly if you have some problems, compliance issues in the file. All right, so we know that TEA has this system in place, and it is voluntary. So you might say, okay, I'm not going to an ARD with you, parent. I'm going to mediation whether you like it or not. We can't assert that. We have to give them the option. Most of the time, I would say that parents are willing to go to mediation, most of the time. And I know a lot of you have been to mediation. Do you like mediations with difficult individuals, or do you prefer ARD meetings with difficult individuals? Why? Because it's caucus style. It's caucus style, meaning the mediator is in one room with the family, the parents, and the advocates, and the attorneys, and whoever else they brought in to play that day. And then your attorney is in the room with the school people, and you have the mediator going back and forth with some ideas, some suggestions, ways to resolve the dispute. So you don't really sit there face to face. Every now and then I'll have a mediator suggest, I think we should start together. And I'm usually like, not such a good idea. We've had about 10 ARDs, all disagreement, and I don't think if we get together it's going to promote any type of peace or well-being. So it's got to be voluntary. Now, confidentiality. If you've been involved in mediation, the mediator requires you to sign a pledge of confidentiality, meaning that you're not going to talk about to anyone else what went on, what were the negotiations that transpired. Hi, Melanie. Yeah, that transpired during the course of the mediation. And it may not be used as evidence against you. Like, for example, if you tell the mediator, okay, mediator, you're right. Our speech therapist was not available for the past 7 months. The child did not get speech therapy for the past 7 months. We don't want the mediator to go run and tell the parents that or, proclaim that. That's confidential negotiation. But it tells the mediator, what we are willing to do is offer compensatory services for 7 months, and this is what it would look like. But you don't want to go back and forth to where it's like, aha, gotcha, you told me this, you told me that, or the mediation process would never work. So, once the parties sign the agreement, and this is what I said previously, it is a binding contract. Some of your parents need this type of arrangement to keep them focused on what they are required to do under the law. We have lots of different types of agreements out there. That's one thing I can tell you. You may think, oh, I saw this settlement from Walsh Gallegos or from Cynthia Beekler or whoever. They're all the same. No, they're not. Every single settlement agreement is different. They're not like your car buying agreements. They're all different. Why? Because I represent special education directors. You're all different. You have different demands. You want to customize. You have different ways you want to write things. You have different ideas. They're all going to be unique. So I'm saying that to suggest if you're like in the middle of a mediation, you're doing it yourself and say, oh, I had an old one from whatever. I'll just use that one. Be very careful on that. Because what you're doing is you're signing a legal contract, just like it would be for the purchase of a house, buying a car. You're going to be responsible for everything in that agreement. Now, from the school district perspective, what I recommend is I want to make sure that somebody keeps track of the promise list in the mediation agreement. Because a lot of times they may be some extensive types of compensatory claims or compensatory services, tutoring, follow-up, monitoring, training. We have all kinds of provisions that may have been negotiated, and you've got to have somebody keep track of those because you're responsible for doing that. I'm going to heighten my level of responsibility on that even than I would an IEP. This is a contract, different level. You violate a contract, it's a breach of contract, you can go to state court or federal court to enforce the agreement. Just like when I said the parent who sued us over something she released, that's a breach of contract. That's why we sent her a letter. You owe us $35,000, cost incurred, suing us over something you released. That's how that works. And the other thing is the attorneys or advocates, primarily attorneys who really understand the law, they're going to emphasize to their clients, you're going to do this, this, and this. They're going to do just like I'm going to do with my clients and say, you have to follow the terms of this agreement. The same thing's going to happen with the attorneys. In fact, the parents' attorneys like to have specific language telling their clients what to do because it helps them control their clients and rein in their clients to make sure that the agreement's followed. And most of your agreements have a little enforcement provision that's delineated in one of the paragraphs. Okay, like I said, in terms of TEA and options for mediation, you don't have to wait until a due process is filed. I'll have clients call me sometimes and say, hey, we need to mediate with this parent. This parent was previously, we'll say, represented by David Banky or Sir Kill. Can you please call them and see if they'll mediate? I'll initiate the mediation. If you have a good relationship with some of these attorneys or reputable advocates, then you can get things accomplished through the mediation process that otherwise might not be possible. So it's not the same as a due process. Like I said, doesn't have to have a DPH. Another thing is mediators act as these third neutral parties. I'm not supposed to be neutral. I'm not, as a general rule, just from a personality perspective. But I am not supposed to be neutral when I'm representing my client. And as a defense attorney, I represent the school district, and I make that clear, I think, when I'm around the table. And the parent's attorney, they likewise have a job, and they are to represent the interests of their client. What makes this work in the mediation world is that you have that one-third neutral party that can go back and forth, doesn't have a dog in the hunt, so to speak, and goes back and forth and delivers the messages in a more diplomatic manner than, say, I would have delivered it at an ARD meeting. So that's one of the options that makes this a good thing to do. Why? What about the interplay between ARDs? Okay. Mediation can be used in lieu of holding an ARD, as set out in the administrative code. Now, you can only do that, though, if the parents are agreeing to do it as well. What gets tricky, and it's kind of a case-by-case basis, is when I've gone to mediation and I'm trying to resolve maybe several ARD issues in the mediation to preclude going to another ARD meeting. And I want to get everything wrapped up while we have it all, right? We try to do that all together and maybe have an attachment, addendum to show the parties agree to adopt this as the annual ARD. So you need to be, if you do that, you have to be very specific about what it is you're agreeing to. I would put language in there saying that we are not prohibiting convening an ARD, rather the parties are agreeing to use this process to come up with a resolution for programming. Okay. So this is another thing to consider. To get the TEA mediators involved, it does have to implicate idea. It can't just be out here a personal injury claim or a bullying claim or a playground claim. Playground's not accessible. It's got to somehow implicate idea. If you don't, then the folks at the helm at the mediation department get upset and they are wanting to make sure that there's idea claims involved. That being said, when I look at most of you out there where I know I've been involved in mediations with you, other issues arise, other laws arise, such as Americans with Disabilities Act, Section 504, even though it's primarily IDEA. I may have Title IX claims, bullying claims. So what's really important is you want to make sure when you get to that release part that all those claims are released that could possibly be asserted at a later date by the parent. All right, so that's critical, but you've got, TEA is only going to do it if it's IDEA related. I have tried, maybe I'll get Shirley to help me on this, I've tried to convince TEA to allow me to use the TEA mediators when I have co-op disputes. See, sometimes my superintendents in special education SSAs don't get along. And I have tried to convince TEA to let me have a mediator in that situation. But no, that's for this process only, even though ultimately I think it would serve the needs of the special ed students if everybody in the co-op gets along, but not necessarily so. All right, let's look who serves as a TEA mediator. Mostly private practice attorneys. They are licensed attorneys. Who you have as a mediator is critical. I'm not going to up here line out who I think is the most competent or reputable mediator. There are some that are more experienced, and the more experienced they are, the better they're going to be. Because if they understand the IDEA claims, like if a parent says, my child's not making maximum benefit, my child's was not accepted into A&M or wherever. So, you know, certainly they didn't provide my child the services that are needed. An experienced mediator is going to tell them, you know what, here's what the law is on that. You're entitled to some benefit based on the unique circumstances of the child. So you're going down the wrong path. So that's why you need a knowledgeable mediator to when you have parents on claims and parents going down legal paths that do not exist, they can rein them in and focus them and say, look, you're not going to get this anywhere. So a judge isn't going to order it. A judge is not going to entertain your claim. So you want, again, an experienced mediator. Many of them are either former due process hearing officers, and they're certainly not TEA and they're not district employees. So I will tell you that right now TEA is pushing to have a lot of their lesser experienced mediators who don't really know special ed to mediate your claims. If I'm your counsel, I'm not going to accept that because I'm not representing you as I should if I know I'm not going to have an experienced mediator. At times, I serve as the mediator. I go back and forth, and I've been successful at that depending on who my attorney is. And so we'll do an informal dialogue, and it's not the TEA mediation process per se, but it is still confidential under Rule 11 between two attorneys. So what are the likely results? Peace, love, and harmony, that's what I would say. If you're successful in mediation, you can see they say 80% of the parties using it have settled. It's less formal. And I've talked about due process hearings and how expensive they are. You could pay your counsel to sit in a mediation for 8 hours, 10, 12. They can be very exhausting and time-consuming and expensive. But when you compare that to the cost of a due process hearing, then you're looking at like $100 grand, $150 grand to just defend, and they keep going all the way to federal. So, I mean, I've got two right now in federal that we probably might hear something in summer of 2018, and they started in 2016. So it doesn't give you what? Finality. Mediation is finality. That's why I'm a really big advocate of this. So, and then it says, you know, you can repair relationships sometimes. That happens. Now, there are some times when there are some very creative settlement agreements where folks are maybe suggested that they move somewhere else. They go on. They try some other opportunities. Sometimes the relationships are toxic. And in those instances, a school district may really look at some higher dollar values, and the parents will go to another LEA so that that particular school district would not be responsible. That type of a diagram, that type of format, you better get a lawyer involved to help you with that. You may say, well, can we do that? Can you even do that? Could you pay a parent X amount of number of dollars to go away? Yes, you can. You can. And in fact, case law is very clear that parents can waive their FAPE claims by contract. So I'm telling you, contract law is over here. It's superior. It supersedes a lot of this other rhetoric. So you can pay. It's a board decision, a superintendent decision, and it would have to be a very, very complicated, incomprehensible situation. But that can happen if you have the right counsel involved. Okay. There are some mediations where you can handle it yourself. You don't need an attorney. There are some mediations where you can go with the parent. And you could just, and I've recommended this at times. If you have an experienced mediator, I'll say, call, you go ask mediation. The parent doesn't have an attorney right now, resolve it. And if you get it, and it would be a simple agreement, not my 29-page boilerplate, you know, with all this legalese. There's other types of agreements. And so that would be the type of agreement generated when you don't have attorneys in the process. So that's an option. If it's a low-level dispute and you're not looking at attorney's fees, then you may want to consider that. Of course, if it's unsuccessful, we all know that the parents can file a special education due process hearing, TEA complaint, but they could have anyway. Sometimes it's almost worth the try to see if you can resolve it, unless the request for mediation is just totally bogus in and of itself, and you don't see any value you would get for the school by engaging in the mediation process. But I'll tell you, more than any other aspect of the dispute resolution process, mediation is number one. I've been doing this a very long time, and 24, 25 years. And this is the best path to resolution that's available. So I want you to keep that in mind. And this is a new thing I'd like to discuss, TEA complaints. Y'all get the TEA complaints. I'm going to put that on there, Shirley. I'm seeing an uptick in the number of just TEA complaints, not due process hearings, but the complaints. And you've seen this kind of language, right? All right. This is new, and this is a new trend. I talked to Naomi Roach at TEA, and they're trying a new strategy called the local resolution process, and that's even before going to mediation. So remember, the TEA complaints, they're all about compliance and procedures. But it's time consuming, right? I mean, you have to submit 1,000 documents of this and that, whatever they're looking at, to see if you've violated procedures in any way. But what Naomi says in this, they just started, this local resolution, is they will have an investigator / I don't know what, a facilitator, contact the parent if you opt for this. They will contact the parent and say, hey, I'm willing to talk to the school. I'm trying to understand what you want. Is there a way we could work something out together without going through the entire investigation process? So this is new. Circle it, remember it, and that's going to be a way I would suggest handling the TEA complaints. I think the guy that is kind of taking the position of facilitators, Ron Roberts, I'm thinking is who it is. Naomi Roach is over the whole department, but I think he's the one who will reach out to the parents and reach out to the school and try to come up with some sort of collaborative plan without the necessity of an investigation. One of the reasons is I think they're a little inundated too. Every complaint you get, they investigate. And if there's a way they don't have to investigate, just like if a judge doesn't have to hear a case, they'll dismiss the case, right? That's what TEA is trying to do, but also trying to move forward with a resolution that puts the parties in favorable positions in a collaborative manner. And then, of course, mediation is still on the table. If that's not successful, you can go to mediation. But again, the parents have to agree to do so. So any questions on mediation? Who thinks they've had the longest mediation here? Kara's had the longest mediation? 12 hours? That's until you started yelling at the advocate. Yeah, down the hall. I'm like, oh, she's lost it. There goes that settlement agreement. We were close. Yes, you did threaten that. Yeah, yeah.